Now I am going to dictate a legal passage at the rate of 120 words per minute. Let's start. The right of preemption holds its origination to the advent of the Mohammedan rule based on customs which came to be accepted in various courts largely located in the north of India. This law is stated to be largely absent in the south of India on account of the fact that it never formed a part of Hindu law in respect of property. However, this law came to be incorporated in various statutes both prior to the Constitution of India within bracket for short the Constitution coming into force and even post that para. The constitutional validity of such laws of preemption came to be debated before the Constitution bench of this court in B. Ram para. There are different views expressed by the members of the Constitution bench of 5 judges and also dependent on the various state legislations in this regard, even though there were views expressed that this right of preemption is opposed to the principles of justice, equity and good conscience. It was felt that the reasonableness of these statutes has to be appreciated in the context of a society where there were certain privileged classes holding land and thus there may have been utility in allowing persons to prevent a stranger from acquiring property in an area which has been populated by a particular fraternity or class of people. This aspect was sought to be balanced with the constitutional scheme prohibiting discrimination against citizens on the grounds of only religion, race, caste, sex, place of birth of any of them. Under Article 15 of the Constitution, and the grant is given to every citizen to acquire, hold and dispose of property subject only to the test of reasonable restriction and the interest of general public. Para. With the passage of time, such laws of preemption which existed B. Ram versus B. Nath Singh and others, AIR 1962 SC 14762 Supra, in many states were abrogated, and it is only within a limited jurisdiction that it now prevails. One such enactment still in existence is the West Bengal Land Reforms Act 1955 within bracket herein after referred to as the said Act, an enactment with which we are concerned, and it is this very right of preemption and the manner of its application under the said Act which was debated before us. The preamble of the said Act sets forth the tone as under: an act to reform the law relating to land tenure consequent on the vesting of all estates and of certain rights therein, and also to consolidate the law relating to land reforms in the state. Para. The category of landholders are defined under Section 2 of the said Act, and the relevant two provisions are extracted herein under: Borgadar means a person who under the system generally known as Adi Borga or Bhag cultivates the land of another person on condition of delivering a share of the produce of such land to that person, and includes a person who under the system generally known as Kishani within bracket or by any other description. Para. Cultivates the land of another person on condition of receiving a share of the produce of such land from that person, but does not include a person who is related to the owner of the land. As explanation, a Borgadar shall continue to be a Borgadar until cultivation by him is lawfully terminated under this Act. Para. Right of purchase by co-sharer or contiguous tenant within bracket 1 if a portion or share of a plot of land of a riyat is transferred to any person other than a co-sharer of riyat in the plot of land, the borgader in the plot of land. Stop. Thank you.